All right, this is the detention docket for the 323rd District Court. Thank you, Mr. Warren. On December 21st, 2020, just detention, you're back there. Just let you know, Mr. Morano's attorney just brought in a waiver, and so he will not be needed. He's on first today. All right, so this is the detention docket. In order to comply with the Texas Supreme Court Emergency Order number 30, we are not conducting in-person proceedings. However, we are using Zoom, the remote software. In order to comply with the Texas Open Courts Act, we are broadcasting these proceedings online on YouTube for the public to observe what is occurring inside a public courtroom. No, this is still a court setting though, so no portion of this, first of all, no portion of this recording or this hearing may be recorded, copied, or published. Violations are punishable by contempt of court of up to $500 to 6 months in the Tarrant County Jail. And since this is a court proceeding, the court does expect everyone to have their cameras on unless you're an officer of the court and to behave appropriately. So please do not be in the restroom, laying in bed, in your pajamas. No blinking Christmas lights or bright lights behind you that cast out your face. Don't be going for a walk or your jog around the river path and these are all things that happen. Oh, domesticated animals. Please refrain from having domesticated animals walk across the screen. So at this point, Ms. Christy Spencer, Ms. Brandy Gilbert, Ms. Audra Singleton, Ms. Laura, Connie Brunson, all your cameras need to be on. If not, I will remove you from the court proceeding. All right, so we'll go and start with Alan Brazzaville-Vazo.
Right here, Judge.
Okay, Christy Spencer and Connie Brunson, this is your second request to turn on your cameras. All right, so you're Alan?
Sir.
Are you Alan?
Sir.
Okay. Do we have a parent here for Alan?
Yes, Your Honor.
Okay, she's in the room. All right, so Alan, I'm Judge Kim. This is a detention hearing. When a kid, you've been here for 10 days, so I'm reviewing your case, decide whether to keep you here, release you if I keep you here. You see a judge every 10 days while you're here. You have a right to remain silent. You have a right to an attorney. Let's see.
Present, Your Honor.
We're brought in for ag assault with a deadly weapon. There's a shooting call. Somebody shot in the chest. Oh, this is over the music with a neighbor. Yes, Mr. Brazzaville-Vazo. I am concerned about children having guns. I am not comfortable releasing you. I'm glad you're level 1 outstanding, but I'm not ready yet. Sir, sit down. All right, actually, just let him go. Put a note in there, do not release him. DK will not go. No, you just done it. So I'm just not interested in you. So at this point, I just put down, since you stood up in the middle of me talking, that you're not to be released without the district judge's approval.
You already told me that last time.
For me to do that, to decide. So you can go. Merry Christmas, sir. Spencer Gilbert.
Fuck you too.
All right, now you got to bring him back. All right, so what is that you said?
Say fuck you too.
That's what I thought you said. All right, Mr. Gilbert, so is there any reason why I should not find you in contempt for using profanities at the court at this moment?
Yes, Your Honor, I'd argue on his behalf that he's a young man. He's under a lot of stress. He was told once if he was on level 1, he would be considered to be released. And it's going to be a long time before we could try this case.
Okay, do you have any mitigating evidence on what the court should consider in determining what his punishment should be for the contempt of court?
Your Honor, I would argue to him because of his age. He's a young man. He hasn't got through high school yet. Yet again, he's under a lot of stress and does want to be released because he believes he's innocent of the felonies charged with.
Okay. So he is 16 and 4 months. All right.
And Your Honor, I'd request that you put off any hearing on contempt until after his charges are disposed, as those would could prejudice his sentence in the underlying cases.
I will grant that request, Mr. Green. The court will take that under advisement and deal with the contempt at a later date. All right. Well, I tucked it away in the file box up here, right? So, all right. Well, just so you know, Mr. Let's say Allen, decisions have consequences. So, all right, we'll see you in 10 days. All right, we'll deal with Mr. Spencer Gilbert.
May I be excused, Judge?
Yes, thank you, Mr. Green. Merry Christmas, or, well, you don't observe Christmas. Happy
Thank you,
holidays.
sir. I appreciate it.
Happy
Bye.
winter solstice, I think, right?
Thank you, sir. Bye.
Mr. Gladstone.
One of those holidays.
I try to be cognizant. I wish you a happy Hanukkah.
Yeah, I did remember. Thank you, Judge. Merry Christmas to you. We don't see each other before then.
All right. We have Mr. Gilbert here.
Yes, sir.
All right. Hello, Mr. Gilbert. I'm Judge Kim. This is a detention hearing. The law says when a child's been brought to our facility, you have to see a judge within 2 days. I have decided whether to keep you or release you. If I keep you here, you can see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Your attorney is Mr. Gladstone. All right. So, Spencer, 17 years old. See, we issued a warrant for you on December 10th. We got an email from Johnson County saying you got in trouble at home for a cell phone incident at school and not doing your schoolwork. Sister gave you the keys so you could sit in the car and calm down. They realized that you took the car and the car was gone. They've allowed you to drive around the neighborhood before, but you weren't in the neighborhood. So, see, a couple days ago, Mom said that they recovered the car. They had the car. You're still on the run. You sent a text saying that you drove the car to Fort Worth and abandoned it, and she had to get the car back from it, pay an impound fee. And they dropped the UUMV case. All right. Give you a drug test, you're negative. All right, so, Mr. Gilbert, hopefully this is just a poor decision it's a one-off, in that this isn't who you really are, and you just made a bad choice. But when the courts had to get involved and go ahead and issue a warrant, and the police had to go pick you up and bring you back here, I'm going to go ahead and detain you. We'll see what your behavior level's like. We'll decide whether we're going to release you or not after that. I'll let you know if your behavior level drops since you're 17 years old. I can send you to the adult jail in downtown Fort Worth. So I encourage you to make sure your behavior level is a 1-0. That's the one way you can guarantee that you're going to stay here. If your behavior level drops a 2, I'm going to send you downtown. If it's somewhere in between, it just depends. All right. So you know, did you have a question for me, or did you want to tell me something?
Yes, sir. Yes,
Okay.
sir.
What's your question?
When they picked me up, I was on a list as a runaway, and I was with my mom at the time.
Is that it? So what's your question?
So how was I listed? How did I have a warrant if I was talked to my PO on Friday? I had just
Because once the warrant's issued, then you have to come back to the court to lift the warrant. Just because you talk to the PO doesn't mean it automatically gets lifted, right? You're under supervision. We expect you to be accessible. If you're not, then we issue a warrant and you have to come back here.
Okay, so how long am I supposed to be staying here?
Well, that's really up to you. If you misbehave, you're not going to stay here for very long at all. You'll go downtown jail. If you behave, you'll stay here for a little bit longer, and we'll decide whether to release you or not. But it's going to be at least 10 days.
I really want to go home for Christmas though.
Well, I'm sure you do, but I really wanted you to stay at home before Christmas, and you didn't. You ran off.
But I was just upset at the point. I was upset at the moment. I wanted to be away for a second.
Well,
I didn't want to do nothing.
at a certain
stupid.
point, you thought it was worth it to drive off to Fort Worth and abandon the car. And you said, if there's a consequence from the court, it's worth it to do this. And so,
No, it wasn't like that, Judge Kim. It wasn't like that at all. It was that I didn't want to risk doing nothing else stupid.
so you're telling me I should reward you for only taking a car, running away, and ditching the car in Fort Worth?
No, you shouldn't reward me for anything. But I wanted to leave so that way I wouldn't do anything stupid. So that way it wouldn't cause me to had to stay somewhere else. Had to really go to the county.
I'm not going to congratulate you for not committing a felony. You're not supposed to commit a felony. Raise your expectations. You got to raise your expectations to match mine. I expect big things from you. If you make bad decisions, bad things are going to happen. All right. All right. Thank you, Mr. Gilbert. Nathaniel Nix.
Thank you, Judge.
Thank you, Mr. Gladstone. Oh, that was a very novel argument.
Judge, there's no parent present.
All right. Thank you.
For this young man. She's gonna be at work till 1:30.
I understand. All right, Mr. Nix, I'm Judge Kim. This is a detention hearing. It's attorney requested detention hearing. All right, so you're 16, you're almost 17 years old. You've been here for 8 days and you're level 1 outstanding. So, Ms. Herrick, are you here? Ms. Herrick's not here. Okay, let's put her back to the list at the end of this and we'll get back to Mr. Nix. Ethan Nordyke. It's out of custody detention hearing. Mr. Nix, just hold on. We're waiting for your attorney. I'll be honest, that argument that kid made is kind of the argument I expected Richard Gladstone to make. It's kind of appropriate.
I've actually made that argument.
And Miss Abels, you would not let me down either.
I've made it.
Did it work for you, Miss Abels?
No, sir. I wanted to tell him to stop. That didn't work. I've tried.
Okay. All right, Mr. Nordyke, I'm Judge Kim. This is a detention hearing. My decision now is to take you into custody or to keep you in the community. If I take you into custody, you see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Your attorney, Mr.
Maybe.
Willett, I believe is here. I think I saw. There we go.
Judge, that's me. I'm sorry. Ethan Nordyke?
Yes.
That's me. I'm sorry, Your Honor. I don't know if Mary told you.
Oh, you got retained on this?
No, Ethan was, it's kind of a long story. I don't know if you have time, but I'm going to be his attorney. I've represented him twice and already talked to the granny. I don't know if Brian has or not.
No, I didn't. I just
All right,
got
so if
Friday.
Sorry, Brian.
Okay.
Brian, we'll roll you to the top of the list so you get the next one.
Okay.
All right, thank you. Is
All right.
this your only one, Mr. Willett?
Yes.
Okay, have a Merry Christmas.
Sorry,
You
Brian.
too. Thanks.
Yeah, if you can put Brian to the top of the list so he gets the next appointment. All right, so let's see, Ethan.
Yes, sir.
10 days ago, we got a referral for out-of-custody referral for ag assault, ag robbery, and ag assault. According to the police report, police were dispatched to Janetta and Cummings for a victim about getting robbed. So he was walking Janetta. He was approached by unidentified suspect. They flashed a handgun, demanded the wallet. Victim said the suspect stole his wallet and cell phone and hit him in the face with a handgun. Well, Ms. Hall, how does he link to this one? Oh, no, I'm sorry. That was a report from November 12th.
Judge, I'm covering for Joy Hall. She's out this week.
Okay.
The DA actually asked us to go ahead and bring him forth to you because of this offense where he was accused of robbing 3 victims with a handgun.
That's November 12th incident. November 13th, North Hills, there's a student said got robbed. Student who's now victim 2 said driven to victim 1 to sell weed. Victim 1 was selling weed, robbed him at gunpoint. Drove from Grayson Ridge to Parkwind. They got there at 6 o'clock. Suspect opened the rear door, displayed a gun, racked the slide, demanded all the stuff. They said they didn't have anything. He struck him in the head. Pictures of the injury. All right, Ms. Campos, so far I don't see anything that actually identifies Ethan here.
Judge, if I can jump in there.
No, you can't. You can't. By statute, it's not adversarial.
If I can point the judge to the port in the parts of the offense report that.
Okay, sure.
Yeah, if you look at the November 14th portion that talks about the detective,
Okay.
one point says that a witness they interviewed said that Ethan said he intended to rob the seller of the marijuana. They found a phone, the stolen phone, which had his fingerprint on it. And then if you look towards the end, right before it says offense history, 2 paragraphs up, the photo lineup, victim 1 identified Ethan, though wasn't 100% sure.
Okay.
Are kind of the highlights.
Okay. Some reports, crime scene said they got the fingerprints from the victim's cellular phone and compared it to Ethan's fingerprints, and they were confirmed. Okay. All right, so this. All right. And Ms. Campos, his probation's expired for the robbery?
No, I don't believe so.
He said he got probation August 15th, 2019. Oh, no. So he's on probation. Now he got picked up for an aggravated robbery?
Yes.
That's why the name's familiar. All right. Okay. Well, at this point, Ethan. So this is the first time, this is out of custody referral for the aggravated robbery, correct?
Yes.
Okay. All right, Ethan. So you understand my feeling about kids with guns. I have a big problem with that, and that I detain them. And the fact that you're on probation right now gives me great concern. Before we give you a drug test, anything you want to come clean with?
I'm positive THC, but that was
THC?
like 2 weeks ago. But
All right. Yeah. So, it'll show up in the drug test. So I'm glad you told me. I'm glad you're being more honest and forthcoming. So, Mom, I hope you understand that, this is not acceptable behavior. So we're going to take you in custody. We'll see you in 10 days. I'm going to let you know, Mr. Nordyke, you shouldn't get your hopes up by getting out in 10 days if you're level 1-0, because it involves a gun. I take this very seriously. I go very cautiously whenever kids have guns, okay?
Mr. Judge, can I please speak?
Well, if you want to ask me a question, go ahead. If you want to tell me something, I know your attorney does not want you to tell me a story, okay?
No,
So do you have a question for me?
I have a question.
Yes, I'm happy to answer a question.
Do you think you could please put me on the monitor so I can keep my job? And so I think my girlfriend may be pregnant and I just want to stay out with her.
No, sir. So when kids have guns, that's just the greatest concern for me. It's not just let you go and hope for the best. I've got to be extra careful. We just adjudicated a child for murder today, this morning, before this hearing. All right, kids with guns really ends up with really bad situations, bad consequences. All right, this is just good decisions have good decisions come from experience. Experience comes from bad decisions. I hope this is an experience. If you did it, there's still the presumption that you didn't do it. All right. Thank you, Mr. Nordyke. Jordan Saunders.
Thank you, Judge.
Thank you, Mr. Adler. All right, Ms. Taylor.
Good morning, Judge.
Good morning. All right, so Jordan, this is a attorney requested detention hearing. If I keep you here, you'll see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Ms. Taylor is your attorney. Ms. Taylor, for what purpose did you request this?
My client asked me to request a detention hearing because Christmas is coming up and he understandably would like to go home. Moreover, he had a detention hearing a week ago, I believe, and Judge Porter, and at the previous, when he was previously detained, I believe he's been level 1 outstanding. Judge Porter indicated that he was very happy with his behavior in the detention facility, but he just wasn't comfortable yet releasing him. It's my understanding Jordan's maintained that behavior and he wanted me to try to get in before the court closes for Christmas and asked to be released on a monitor. I've had a lot of conversations with him.
Sure. So Jordan, just so you know, Christmas itself means nothing to me as far as detention hearings. All right. Just because it's Christmas, I'm not sentimental about that. I'm just going to look at it like it was any other day. So you're on probation for theft. That was from November Wait, he just got on probation?
That's correct, Judge.
And then 5 days after he's on probation, he was caught breaking into a house.
Oh, no, no. I think the allegations are, nothing's been filed yet other than the count 4 has been added into text share for the violation of a court order, violation of probation. He was, without going into too much detail, it was late at night. I've already addressed with his parents why he would have been out at that hour, and I've received it.
Hold on a second. So he got placed on probation November 20th. On November 25th, he was referred by Mansfield, saying that about 3 o'clock in the morning, they were dispatched a suspicious person call on the Ring doorbell. They ran off. They patrolled the area, found 2 people inside. When the police got there, the 2
Inside a
people fled.
vehicle.
I'm sorry?
Inside a vehicle, Judge.
Inside a vehicle. Then they fled on foot and were apprehended. And let's see, they found stolen items inside the car and work tablets, purse. They forgot to lock it. Okay, so the owner of the car said they forgot to lock it. Yeah, I missed it. All right, Jordan. So less than a week that you're placed on probation, that you're caught 3 o'clock in the morning in a car with a bunch of stolen goods. And so if I release you, you're just gonna break into more cars or be part of other people breaking into cars. So I'm not gonna release you. I mean, people deserve to be able to keep their Christmas gifts that they're gonna get. Yes, Mr. Saunders, you have a question for me or you want to tell me something?
I would like to say something, not a question.
You want to tell me something, your attorney does not want you to tell me something. If you have a question, I don't mind answering.
It's not about my case, sir.
Well, that's something you probably want to bounce off your attorney because I don't want you to put yourself in a spot. Okay?
It's good. It's good things. I was just gonna say that the last time that I was on a monitor that I did good, and I took the initiative trying to show you that I'm gonna do good by keeping a 1-0 in here and continue doing good, sir.
Well, I mean, please do. I'm glad you're a level 1 outstanding. But again, I do not look at Christmas as anything special for detention. It's another day. When kids, and part of the thing is, if you in fact were breaking into these cars on November 25th, 5 days after you're on probation, you should have realized that you were this close to Christmas and you got caught, you would be spending Christmas at Kimbo. Right? So I'm just saying, I don't know if you actually did it or not. I don't know if you're involved or not. That's for your attorney to fight. What I see is 5 days after you get on probation for theft, you're caught in a car with stolen goods at 3 o'clock in the morning. So you did not take your probation. Like, probation means something.
But if I was on house arrest, how would I be able to rob people, sir?
Well, the monitor doesn't keep you from robbing people. It just tells us where you are when you rob people.
But I would be at the house, sir, since I'm on house arrest, sir.
But you weren't at the house. You were in a car on the streets at 3 o'clock in the morning.
But I wasn't on house arrest, Your Honor.
You had an order of probation that you're supposed to be at home.
Yes, Your Honor.
So yeah, I mean, you weren't where you're supposed to be. Having the monitor wouldn't physically keep, it's not like it shocks you when he walks outside the house. Although, Kelly, we need to start ordering some of those, right? So, but yeah, no, you were free to leave, and you did. And so at the very least, you're outside the house in violation of your probation, right? So it's gonna take me more time, but I'm not willing to release you. It was only it wasn't even a week that you were on probation before you were already outside the house. Ms. Taylor, I understand your client asked you for this hearing, so I don't blame you, but I hope you understand where I'm coming from.
I do, Judge. I appreciate your time and your consideration.
You're welcome. Merry Christmas, Ms. Taylor.
You too, Judge.
All right,
Yeah,
yes, ma'am. Jada Singleton.
Judge.
All right, thank you. All right, Ms. Singleton, I'm Judge Kim. This is a detention hearing. You have the right to remain silent. You have a right to an attorney. If you cannot afford one, we'll provide one for you. Ms. Abels is your attorney. All right, Ms. Abels, for what purpose did you request this detention hearing?
Judge, we had a detention hearing, I believe, last week. And at that time, Jada had a psychological scheduled for Wednesday of this week. And so Judge Porter asked us to reset the detention hearing on Wednesday after her psychological, whatever time that was. Well, they've moved her psychological to, I believe, December 30th, and her adjudication hearing was set for January 5th, and it got moved out farther as well. So Jada has an aunt, I believe it's an aunt that she can go live with who may be here today with her mother.
Yeah.
Is she
Yes,
here?
she is. Yes,
Okay.
Miss Laura is the aunt, Miss Laura Smith, and then mom is on as well.
Right. And I'd heard that the aunt was coming too. And so since they moved everything out farther, I thought that I would set the detention hearing that Judge Porter asked for last week.
Have we done the psychological?
It's not gonna, this is like the fourth time it's been scheduled.
Yeah.
And so one time she was STAR testing, another time they didn't show up. They reset it to this Wednesday. I don't know why it got reset until the 30th.
At this point, yeah, I'm sorry, Key. At this point, the female unit is quarantined, Your Honor. So it was originally set for the 23rd after the STAR testing had it to be reset. And so because the female unit is under quarantine, it was reset now for December 30th, which is when the unit will be out of quarantine.
So she is on probation for ag assault, deadly weapon. Is that correct?
Yes,
Yes,
and UUMB.
Who was the victim on that case?
Was it mom?
It was sister,
Sister. Okay.
How old is the sister?
19.
19.
All right, so Ms. Judd, are you covering for Ms. Burns?
I am, Your Honor.
All right, well, I can put you on the spot. What's your recommendation?
I do have Miss Laura on, the aunt. I did speak with her. She is concerned about the quarantine status. She does live alone. However, her grandson will be visiting over the holidays, and with the quarantine status up on the 30th, which is the day of the psychological, I believe it would be best for her to remain in detention until that date where we can get it all done.
Yeah. So, Singleton, this is where I'm on the fence, right? I can go either way on this one for varying reasons. One, your behavioral health, I'm glad. Part of what working against you is we need to get the psychological, and you have a history of running away. I don't know if you'll come back for a psychological if we let you go. The plus side is, you're 17. I almost feel like you're almost an adult and you have your own decisions to make. That's kind of makes me want to release you, but part of what makes me want to hold you back is the fact that that you have a history of running away with adults, and that makes me really uncomfortable. So it's just, there's a whole bunch of things that are counter-competing on this one.
Judge, this is a case where she and her mom have issues.
And this is where that lady just showed up saying, I'll take her in.
No, yeah, it is, but this is an aunt that mom approved.
Right. But this is the case that
Yes,
that
sir.
lady.
Yes, sir. And Jada's been on level 1 outstanding since she's been here. Now, having said all that, I understand the COVID and quarantine issue. And Jada and I haven't talked about that because I didn't realize they were in quarantine until a certain day. And she couldn't come in our house right now. I can tell you that because we've all been exposed. Anyway, so Miss Laura, I believe Miss Laura really wants to take her. I believe Miss Laura will return her. But
I'm not worried about Miss Laura. I'm worried about Jada.
I'm not that worried about, I really am not that worried about Jada. And because she's run away, I'm just not that worried about that. But I've had multiple conversations with her that you haven't had. I believe Miss Laura would bring her back for everything she needs. But Jada, we got to do what Miss Laura says. Just like I told you yesterday, you got to do what Miss Laura says, and that starts now. And
But Miss Laura is the aunt, right?
Yes, and if Miss Laura is having company over Christmas, Miss Laura doesn't want somebody who's been exposed in her home. We have to respect that. We also have to respect what Judge Kim says, or act like we do. And so,
She has a point.
and so, really and truly, what those two say right now is what's going to matter. You still level 1. You still been level 1 the whole time. I think you've learned a great deal being in here. I think not going home to your mom.
Judd, how long has she been level 1? I don't show a date.
Since November 12th, Your Honor. Oh.
Hand down.
Jada,
Yes.
get a level 1 back there. What happens if, I think I give you the pin sheet. What's a DNA back there, Jada? DNA back in detention. What does DNA mean?
Do not associate.
Right. So what happens if Miss Laura says, do not associate with this person?
Miss Laura,
Yes, Miss Laura.
I don't associate with that person.
Right. What does slow to comply mean back here? Failure to comply.
Can you repeat that?
What happens if you're slow to comply here at Kimbo? You lose points, right?
Yes.
Do you understand? You're level 1O back here. I'm expecting if I release you for you to be level 1O with Miss Laura, right?
Yes.
So if we get a phone call saying Jada's just not listening to us, she won't get up, she won't clean up, she won't do chores, what do you think I'm gonna do?
Put a warrant out.
Yeah, you gotta be level 1O if I send you home, okay?
Okay.
Miss Laura, are you here? She's just in the, there you go, Miss Laura.
Yeah.
Miss Laura, knowing that she's been in the quarantine pod, so there are interactions with certain children that are COVID positive, are you still wanting Jada, to come back with you?
Is she negative?
She is negative, but she could have been exposed. I mean, she has more or less been, she's living in close proximity to other people who are positive.
I'd rather that it be tested again and that it come out negative.
Well, it is negative. She has never tested positive, okay? But you have to understand, it's a detention facility, so there are detained children and adults that periodically test positive. There's no way to tell. So there's a 2-week incubation period. So we could test her today and she's negative, but that didn't mean in the last 2 weeks, if she came across somebody and became infected, then it wouldn't show up yet on the test.
Okay.
Do they ever get out of their rooms during quarantine?
They do, but they have to take showers individually, they eat in the cafeteria individually.
So they're never in a group during quarantine.
They're not in a group setting during quarantine.
Okay, then.
Are you okay with her coming with you?
We'll make it happen.
Okay, well, I will do that, Jada. So Jada, just so you understand, I'm not doing this because Judge Kim has a soft heart and it's Christmas time, right? I'm doing this because you did your part and to do the right thing by being level 1O for an extended period of time, right? And you're talking to me like you're actually going to be responsible grown up, okay? So you earned this one. This is not a gift this is not a Christmas gift from the judge. This is you earning it. Remember when I tell you good decisions come from experience, experience comes from bad decisions. And it looks like you're making some good decisions, all right? So I want you to take this and go forward. Any questions, Jada?
No.
Judge,
Your Honor.
Are you gonna let me down?
No, sir.
All right. Do you think I'm gonna bring you back here if you're causing problems?
Yes, sir.
You know I will, right? All right, thank you. Ms. Abels, were you saying something?
Yeah, Miss Laura is in charge of who Jada sees, where Jada goes, and all that, right?
Yeah, Jada, she's issuing the DNAs to you. She's like, you can't hang out with them, you can't hang out with them.
Okay.
I'm not, so that means that Audra Singleton, even though she's Jada's mom, right now she's not making those decisions. Is that
Ms.
right?
Laura's making those decisions. I'm releasing to her. And the reason why, Jada, is because if you run off, I can put Miss Laura in jail until we can find you.
Don't do that to Miss
You
Laura.
understand that, Miss Laura? Like you're signing her out. So that means if she runs off, you're responsible and I can issue warrant for you until we find Jada.
Okay.
Are you willing to take this responsibility?
Okay.
You are willing to, you're going to sign a piece of paper just to make sure you understand that, right?
Right.
Okay. All right. If she, Jada, this is, your past decisions can come back and get you sometime. All right? All right, thank you, Jada.
Your Honor, I'm sorry.
Yes.
I just want to clarify. Was that electronic monitor or no?
Yes, I've already signed the EM order.
Okay, thank you, sir.
Thank you, Ms. Judd.
Thank you, Judge.
Thank you, Ms. Abel. Jacqueline Spencer. Start thinking of a soft heart.
You do.
Attorney requested, yeah. Okay. All right, Mr. Spencer, I'm Judge Kim. This is a detention hearing. I'm deciding, oh, you've been here for 10 days, so I'm reviewing your case. You're level one outstanding. You have been for 3 days now. Let's see. You were not on probation. There's an ag assault. Police arrived, detained Jacqueline. He had some weed in his pocket. They were dispatched for a shooting. Guy was shot in the leg and hit his femoral artery. Your surgery. All right. Well, my first question, Ms. Turnerhill, why did he drop down from level one? What happened?
Your Honor, he got into a fight in detention, and so he was a level 3, and so he's just working his way back up. But the fight was on December the 4th, and it's my understanding the victim wants to press charges. We just haven't received the police report yet from the Sheriff's Department.
Sure. All right, so Jacqueline, you're here on a gun charge. You understand that gives me great, great concern. But the fact that you're back here getting in fights and causing problems, I'm not ready to release you to the community. So I'm going to go ahead and detain you. We'll see you in 10 days. All right, so security control, Nathaniel Nix, the attorney requested his detention hearing, but we can't find her. So I'm going to put this aside. Judge Porter's going to take over the rest of the detention docket. If she shows up, we can have the hearing. If not, then we'll just see him at the regular scheduled 10-day.
Yes, sir.
So Judge Porter is going to take over the docket from here.
Thank you, Judge.
Thank you, Mr. Adniji.
He wants to fight me.
Miss Laura, you can go. Can Miss Laura go?
Okay, thank you.
But wait, you got to meet with Miss Judd, okay?
Okay,
Like, don't
so
go home.
I'll call her. She's not here right now, Keith, so I'll call her.
Okay, then stay home. And no call.
okay,
Thank you, Miss Laura. And hey, will you give Miss Laura my number? Okay, thank you. If you need something, you call me, okay? Because I'll come
Okay.
beat her up.
okay,
I probably shouldn't say
All
that
right.
on Zoom, but that's all right.
okay, thank you. Bye-bye.
Your Honor, I think this sounds a little messed up.
Judge Porter, we cannot hear you. We cannot hear you, Judge Porter. We're on FPOD. We can't hear you. I don't know if it's our computer or him.
I can't hear him.
One moment. I think that's what he said.
his computer was tempted, so.
Ms. Abels, are y'all able to hear me now?
Yes, sir.
All right. Are you Miss Brunson?
Yes, ma'am. Yes, sir. I'm sorry.
All right, Ms. Brunson, the court is aware of the underlying facts in this case, also aware of your continued lies to this court on not one, not two, but on 3 different occasions. And you are likely to abscond if I were to release you from the detention facility. So I'm going to order your continued detention. Thank you, Ms. Brunson.
Hey, wait, can I just say, forget it.
Yes, Ms. Abels.
I didn't know till this morning she was there. And so I will make contact with her and see if we can get this worked out.
All right.
Merry Christmas, y'all. May I be excused, Judge?
Yes, thank you, Ms. Abels.
Thank you, sir.
That was it. I'm not sure what exactly going on. Yeah, so that's it.
Judge, we're unable to hear you, sir.
Mr. Richmond, are you able to hear me? Okay, Jorge's shaking his head. All right. Iden Hagel. Good morning, Iden. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. Is Mr. Daniels here?
Yes, I am here.
Oh,
Your
okay.
Honor.
Keith is here. All right. No, Harmony, I'm sorry.
Hi, Your Honor.
Is your attorney. Ms. Sherman was here. Is she still here?
I'm here.
There she is. All right. Iden, you were kicked out of Lake Granbury. You're level 1A today. I'm convinced that if I were to release you, you would reoffend. And so on that basis, I'm going to order that you be detained. Thank you, sir.
Thank you, Your Honor. Thank you, Your Honor.
And now I can't hear anybody talk. Mr. Richmond, can you say something, please?
Yes, Judge. Can you hear
Okay,
me?
I can hear you. Okay, barely though. All right. Jeremy Hauser. Are you Mr.
Yes, sir.
Hauser?
Yes, sir, I am.
Mr. Hauser, the law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Mr. Daniels, your attorney, is here. Do you see him on the screen?
Yes, sir, I do.
All right. You've been level 1-0 since yesterday. Mr. Daniels, what are your thoughts?
Your Honor, I'm not sure if you're aware, but he is in CPS care right now, and I'm not sure if CPS is here or not. But I did talk to Mr. Gorman, who is in charge of his case, and right now I know he doesn't have a placement for him right now. And I also, when I did talk to Jeremy, his conduct level had dropped in detention. I'm not sure where he is this morning, but I know he does not want to be here. But from what I have seen in the probation report, they are planning to do a psychological assessment and also a placement staffing, a resource staffing.
And Mr. Miller, has that psychological been scheduled?
It has, Your Honor. It's scheduled for Wednesday, the 23rd.
All right. And he is level 1-0 this morning, is that correct?
He is level 1-0, but he just made that level yesterday. He was level 3 confined back on the 15th for negative peer influence.
And who are those people in the parents' room?
Biological mother.
And?
Jamar with our community, our kids.
Okay.
I'm a caseworker.
Mr. Daniels, did you have any questions?
Well, if I could just ask Mr. Gorman what his thoughts are this morning.
I spoke to the intake specialist who's assigned to find Jeremy placement, and so far no placement has accepted Jeremy due to his behaviors. RTCs are reluctant to take him. They said the risk is too high. Foster homes, the same thing. Jeremy's ran away from placement, I believe, now 12 or 13 times. I believe this is like our 4th time here that he's been detained from running away. That's where the issue is, that placements, every time he runs away, he's getting involved with gangs now, more dangerous. So placements are hesitant to take him in.
May I please say something?
You may ask a question, but I don't think your attorney wants you to make a statement. But if you wish to ask a question.
Well, I wrote something for you.
You need to give that to your attorney and let your attorney evaluate it. Because if you make a statement here, while it cannot be used in an adjudication or disposition hearing later on, or even at a modification hearing, it might give the district attorney's office ammunition to use against you. And I don't think your attorney wants you to give them ammunition to use against you, do you?
No, sir.
All right. So do you have a question?
I do have a question, yes, sir.
What is your question?
You know, I know that I was a 3.
That is not that's a statement. That is not a question.
May I
What
please,
is your question?
Do you think it'd be possible that I could get released on EM or extended probation or something? I just don't want to be in here for Christmas.
I understand that. You will need to discuss those options with your attorney, but your history of running away, I believe Mr. Gorman said in the neighborhood of 14 times, gives me great pause to believe that if I were to release you today, that you would either maintain level 1-0 at any placement that he could find for you, or that you would return and not abscond from the jurisdiction of the court. So because I believe you're likely to abscond, I'm going to order your continued detention. Thank you, sir.
Yes, sir.
Thank you, Your Honor.
Thank you, Mr. Daniels. Terrence Deshawn, Price Tucker.
Good morning, Judge.
Good morning, Mr. Youngblood. All right. Are you Mr. Price Tucker?
Yes, sir.
Mr. Price Tucker, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Youngblood, is here. Do you see Mr. Youngblood on the screen?
Yes, sir.
All right. The court previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to order your detention in this matter for the offenses of YYYYMMDD and evading arrest or detention. You were also on probation with this court. Mr. Howard, why was a drug test not administered on November 23rd?
I'm pretty sure it should have, Your Honor, but from what I've known, he tested negative.
The report presented to the court shows that when he was detained on the 23rd, he was not administered a drug test. Okay, so it appears that's just an error.
Yeah, that's just, yeah, it should be.
Okay, so he was drug tested. That's good. Hey, Mr. Youngblood, what are your thoughts?
Well, on the one hand, not overly serious type cases. On the other hand, he was on probation, and I'm sure it was a violation of his probation to leave home. And then, of course, he ran from the police, and those are factors against him. Factors in his favor is that he didn't test positive for any drug and that he is on level 1. Oh. So
he's level 1 acceptable.
Yes.
Oh, it's okay. I misread that. So I'm considering asking the court to do an EM release.
Does he have a parent or guardian here today?
I haven't seen them, but there's so many people on the screen, I can't tell.
Your Honor, she
Mr.
called.
Howard,
She called today. She's not on the, I don't see her on the screen, but she called me today and said she'd be there. She's usually at every detention hearing.
Okay. Well, it appears I do not have a parent or guardian to release you to today, Mr. Price Tucker. So I'm going to order your continued detention. If you get back to level 1-0, then Mr. Youngblood, we can reconsider this. All right,
Yes,
that'll
sir.
be the order of the court. Thank you, everybody.
Is it okay if I say something right quick?
You may ask a
you don't
question.
need to say.
Yeah, I was asking a question.
What is your question, sir?
I was asking, I'm supposed to be back at level 1-0 tomorrow, and I was asking if I be level 1-0 tomorrow, will I get released?
It's not automatic like that. We will have detention hearings on Wednesday. Mr. Youngblood, if you can arrange for mom to be here, and if Mr. Price Tucker is still level 1 on Wednesday, we can reconsider it then. All right.
Okay, well, I appreciate it.
Pinky
May I be
promise.
excused?
Yes, sir. Thank you, Mr. Youngblood.
Merry Christmas.
Hmm? No, okay. All right. Are you Mr. Promise?
Yes, sir.
Mr. Promise, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to an attorney, and Ms. Tillman, your attorney, is here. You also have the right to remain silent and not say anything at all. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in this facility. The purpose of this hearing is to determine whether you should be released to a parent or guardian. Okay. The police report indicates that on November 21st, officers were dispatched to a robbery call and that someone had stolen a 2019 Chevy Equinox. They made contact with the victim who said she last saw her vehicle at 8 p.m. the night before the residence. She woke up the next day and observed that her vehicle was missing. And she gave no one consent to use her vehicle at any time. Thereafter, police were informed that the vehicle had been seen traveling north on Campus Drive toward East Seminary. Officers located the vehicle and attempted to stop the vehicle. The vehicle began accelerating at a high rate of speed, even though the officers had their overhead lights and sirens on, and they were in a marked police vehicle. The vehicle kept evading. Eventually, while evading officers, a sporting 7.62 rifle, commonly called an AK-47, was thrown out of the vehicle. Ooh, this gets worse. Officers conducted a felony stop and removed you from the driver's seat. All right. You were brought into detention. You were administered a drug test on the 27th. The results were negative. That's good. You were unsuccessfully discharged from court-ordered substance abuse counseling at TYRC due to non-compliance. All right, Mr. Promise. I believe if memory serves, I was the one who sent you to drug treatment at TYRC. And so since that didn't go well, since you are on probation, put your hand down. You are on probation. Officers saw a rifle thrown out the window of a vehicle that was evading arrest. What was suspected to be a stolen vehicle. I am absolutely certain, beyond a shadow of a doubt, that if I released you, you would be a danger to the community. And I'm not about to do that. Put your hand down. So for that reason, I'm going to order your continued detention. Thank you, Mr. Promise.
Your Honor.
Can I say something? Oh,
all right. Thank you, Ms. Tillman. All right. Maria Angeles Rios Adorno.
Right here, Judge.
All right. How are you doing?
I'm doing
Rios
good.
Adorno.
I'm doing good. And you said my name right?
Well, that's once out of like 15 times I got it right. So I still got to work up to getting even close to right. All right. Ms. Rios Adorno, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Shaw, is here. Do you see Mr. Shaw on the screen?
No, sir.
Okay, Brad, say something.
Hello, I'm here. Got a blue plaid shirt on.
Oh.
Really cool blue plaid shirt. All right. The court's previously found that probable cause exists to believe that you engaged in delinquent conduct, and we're really just waiting to transfer to Lake Granbury, and through no fault of yours, that transfer hasn't happened yet. So, Mr. Shaw, what are your thoughts?
Judge, it's my understanding that there's a bed open last Wednesday. You can talk to Mr. Alexander about this, but then the client has to quarantine because she was on a unit where somebody tested positive for 14 days. And so it's just, this COVID-19 just keeps whipping us.
Yeah, this is totally not her fault. In fact, you're doing well in the back, aren't you? What's your level in the back?
I'm a 1-0.
Uh-huh. And has been since when?
I'm sorry, what?
And how long have you been 1-0?
I've been a 1-0 for actually almost 2 weeks, and then I'm being honest, I lost my level last week, but I got it right back. And I would really want to go home on an EM for Christmas, at least.
I know, but if I let you go home, you would have to come back into detention for a whole new 2-week period.
Yes, that's fine.
And no, it's not fine, because that just delays everything. And you have finally gotten in the right mindset. I remember our conversation last time about you being ready to go to make the best of this at Lake Granbury. You're going to go do the program. You're going to get out. You're going to be awesome. And with you in the right mindset, I don't want to delay this. and it's looking like that she may get to go next Wednesday. Is that correct, Mr. Alexander?
So as we stand now, we're just waiting for the quarantine to be lifted off of FPOD. As far as the placement at this moment, because this could change in 10 seconds, at this moment, the placement is good. We're just waiting for the quarantine on Fox. So whenever that's raised, I believe will be next week. She should, at this moment, be able to go next week. But
Yeah.
I want to piggyback what you said, Judge. I talked to Marty Angelis almost daily in the last couple of weeks because of the up and down with the placement. She is in a much better place. The up and down, the constant could go, not go. We've been dealing with that, me, her, and her mom, and she's doing really well with it. She did lose her level last week, but it had a lot to do with the constant inconstants of what we're doing right now. And she was just upset and bothered because one day she's going, the next day she's not. Later the same day, she's back to going. And she's handling it very well as opposed to where we were 3 weeks ago or a month ago. So, and I also was told her physical expired. So even if she were to get released, she had to come back even earlier to do a new physical that would have to go with her when she goes to placement. Because her physical for the placement expired, I believe, last Thursday.
Okay. But we can get that rescheduled between now and Wednesday of next week, right?
It's done in detention with Nurse Lynn and the detention nurses.
Awesome. Ms. Rios Adorno, we are not trying to punish you. Completely the opposite. What Mr. Alexander is saying and what I've been saying is we are so incredibly proud of you for the amount of maturity we've seen in you over the last 2 months. I've seen some real growth on your part. And so I just want to keep saying that of how proud I am of you. And I don't want to keep you in detention to punish you. I'm doing it because I actually want to shorten the amount of time it takes for you to get to Lake Granbury and for you to get back from Lake Granbury, okay? Does that make sense? I know it seems unfair because you're doing everything right and it feels like you're getting stuck in detention. And we all know it's not your fault that you got delayed going to Lake Granbury, right? Okay. I want you to remember how proud Mr. Alexander is of you, how proud I am of you, of the growth you've shown, okay? All right. So I got to order you be detained today. That'll be the order of the court. I'm sorry.
Judge?
Yes, ma'am.
I know I'm asking for a lot, but is there any way that we can arrange for me to speak with my daughter?
Yes, we can. JPD, can we allow Ms. Adorno to have a phone call with Ms. Rios Adorno?
Thank you.
Judge, they're on full quarantine. They're not allowed to receive even probation officer calls, only attorney. The only suggestion I have is after detention hearings, if you'd like, she's the last female, you can do a room for her and her mom, breakout room, before I put her back down.
We will do that.
Yes,
Thank
sir.
you.
All right.
Thank you, Judge.
Okay. Jakaya Smith.
Your Honor, I'm covering for Mr. Victorson. The mom says she's in the waiting room. It's Miss Webster.
Okay. All right, Mr. Smith, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Adeniji, is here today. Do you see him on the screen? Lateef, if you could say something.
Can you see me?
I see that.
Good.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in this facility. You're currently level 2-0 in the back as of this morning. Mr. Adeniji, what are your thoughts?
My thought for him to be allowed to go home, spend Christmas with electronic monitoring. We're coming back to court, Judge. I believe on the
Fifth?
on the 21st of January.
Oh.
I believe they are looking for placement for him.
Mr. Smith, did Judge Kim go over the behavioral levels with you at your initial detention hearing? No? Okay. Do you understand the different behavioral levels in the back?
Yeah, yes, sir.
What's the best level?
1-0.
Level 1, outstanding, right?
Yes, sir.
You're not there yet, are you?
No, not yet.
All right. Okay, you got to get to level 1-0 before I can consider your release. Because you're not there, I have to order you be detained today. All right, that'll be the order of the court. Thank you, sir.
Judge Porter, is that only for Judge Kim or also for you and every judge?
That's for me and every judge.
Just making sure.
There's sometimes when we don't get to level 1-0 and Judge Kim puts us in detention too.
Oh.
Y'all just don't hear about it. Yeah. Court coordinator sitting next to me and she says we get put in timeout. It's funny because it's true.
Okay, Judge.
All right.
Am I released?
Yes, sir. Happy holidays, Mr. Adeniji.
Merry Christmas, Judge.
All right. Banquez Jalil Thomas. That's a cool name. That's a good, strong name. Oh, Dusk. I skipped one. Okay. Are you Mr. Sato? Let's get you unmuted.
Yes, sir.
All right. Mr. Soto, my name, is it Sato or Soto?
Soto.
All right, Mr. Soto, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And your attorney, Mr. Adler, is or was here. Is he still here? There's Mr. Adler.
Morning, Judge.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in our facility. You've been level 1-0 for the last 7 days. However, you have a history of running away and removal of your electronic monitor. Mr. Adler, what are your thoughts? I can't hear you, Mr. Adler.
Can you hear me now, Judge?
Can you hear me now, Judge?
There we go.
Now? Sorry. Thanks, Judge. Basically, Judge, just try and give the young man one more chance on the electronic monitor. He has been 1-0, I think, for the last week or the last 7 days. And I would also defer to Ms. Guerrero if she's on the line and see what her thoughts are.
Actually, I'm covering for Mr. Reyes. He's on probation with Jose Reyes.
All right, Ms. Lopez.
Sorry.
Well, Your Honor, I have here the same request that if possible, would the court allow him to go on EM? He turned himself in after cutting that monitor off. He's on probation until November 17 of next year. It appears the parents are there, Your Honor. I understand they're Spanish speaking.
He's on probation for theft of a firearm?
Yes, sir.
How long was he on the electronic monitor before he cut it off?
Honestly, Judge, I do not know that. Try to figure it out here.
Almost 2 months.
Pardon?
Almost 2 months, sir.
Almost a month, he said.
2 months.
2 months.
Yes.
Who said that?
The client said that, you know.
Okay.
I'm the father.
And when he came in, he was positive for marijuana.
Yes, Your Honor.
All right. No, I'm sorry, Mr. Adler. I'm sorry, Ms. Lopez. I'm not yet convinced that if I were to release him, that he would not be a danger to himself as well as the community. Judge Kim obviously had a reason for ordering him to be on the electronic monitor for that length of time. Obviously, Mr. Soto, while he was willing to accept the conditions of probation, he decided he wanted to unilaterally change those conditions of probation. Mr. Soto, that's not the way this works. Probation is an agreement between you and the court that you will behave in certain ways. When you violate those conditions, you're actually breaking your promise with the court. When you break your promise to the court, then the court doesn't have any reason to believe that your statements to the court that you will in the future abide by the conditions that you agreed to have any merit. And while you've been level 1-0 for 7 days, you should have been level 1-0 for much longer than that. Now I realize the reason you dropped to level 2 unacceptable is because you fell asleep in class back in detention. However, that doesn't change the fact that you cut off your EM and you're using drugs while you're on probation. Not acceptable. And so at this moment, I believe that if I were to release you, you would go back to using drugs and cutting off your EM. Mr. Adler, I believe that Dad wants to say something.
Yes, sir.
¿Puedo hablar?
Can he talk, Your Honor?
Sí, se puede hablar.
Thank
Sí,
you.
señor.
Él lo intentó por mucho tiempo. Él no usó, he tried to not use drugs. He tried really
Hey,
hard.
sir, you're not helping your son by making excuses. Say something else, please.
Well, yes, I love him. So está bien.
Thank you.
Never mind.
Lo siento, es que no lo estás ayudando a su hijo dándole excusa al juez. No quiere oír excusas.
Señor.
Mejor es decir la supervisión que le va a dar al niño cuando regrese a su casa y que vas a hacer ustedes para que él nunca use drogas y nunca corte el monitor otra vez, ¿ok?
Gracias.
Gracias, señor. Perdóname que te tuve que hablar así. I'm sorry, Judge.
No, it's fine.
No, todo está bien. All right, Mr. Soto, for today, I'm going to order that you be detained. Maintain level 1-0, and you'll give me reason to reconsider that next time, okay?
All right, yes, sir.
Thank you, Judge. I'm sorry.
Not a problem, Mr. Adler. It's good that the dad has an opportunity to ask questions. All right.
Thank you, Judge.
Marquez Jaleel Thomas.
Yeah, that's an everyone. Thank you.
Are you Mr. Thomas?
Yes, sir.
Mr. Thomas, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to an attorney, and Ms. Mills, your attorney, is here. Do you see her on the screen?
Yes, sir.
You also have the right to remain silent. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention. You're currently level 1O and have been since the 9th of this month, so for about the last 12 days or so. But you do have a history with the department, including a history of removal of your EM. And when you came in on the 6th, you're positive for marijuana and you have a history of marijuana. So, Ms. Mills, what are your thoughts?
Your Honor, he has been level 1O for quite some time. I'll also point out he was initially detained because he fit the description of something, but none of those charges have been brought in. So right now he's just on a technical violation. I do know that he wants to go home. He's been on his best behavior, like you said, since the 9th, has had no problems that I know of. And so we would ask that he be able to go home today on an EM.
Judge Porter, at his initial detention hearing, Judge Kim ordered a placement search for behavioral issues.
Back in November 20th, he initially refused to go to substance abuse treatment. Is that correct, Ms. Campos?
Yes, and I did tell Judge Kim at our initial detention hearing on the 6th that I could get him a bed over at the campus. In fact, I did secure one and his bed was available for today, but Judge Kim did not want him to go to the campus and he ordered a placement search, and placement is actually actively looking for a placement currently for Vonquez.
Oh, and he's on probation for UCW, right?
Yes.
And that's a weapons crime, is that correct?
It was a firearm.
And then his new pending referral that Ms. Mills talked about that has not yet been filed is possibly related to another firearm, is that correct?
Yes, Arlington Police was called to a shooting in progress call.
All right. Well, Mr. Thomas.
Before you say anything, can I just make a statement?
Can you interrupt, Ms. Thomas? Can you interrupt? Is that what you're about to ask?
I was, yes, sir.
All right, please go ahead and interrupt. I didn't mean to be talking.
I wanted to let you know that he was a victim of that, what they're talking about. He was actually in the house that got shot up. It's just that he came outside and was trying to leave, not making excuses, but he came outside and he did run from the police, but he was a victim. He was not doing the shooting. That's all I wanted to say.
Okay. Well, then if that is correct, then Ms. Mills has a lot of good information to work with in the event that the DA decides to file that new case. It sounds like the DA's case may be a little weak, but that's a decision for a later date. The fact still remains, though, that you haven't been real cooperative with Ms. Campos, and Ms. Campos has to be one of the best field officers we've got. She bends over backwards for the kids that she works with, more so than Judge Porter would if Judge Porter was a probation officer. She gives y'all try after try after try, and Judge Porter would cut y'all off a lot sooner than she does. So the fact that you told her no, not probably repeatedly, that doesn't hold well for you, Mr. Thomas. So I'm convinced that if I were to release you today, you would cut off your EM, you would go smoke dope, you would be around weapons, I don't know. But as of today, I'm going to order that you be detained. Thank you, sir.
Yes, sir.
Judge.
Thank you.
All right. Is Miss Herrick here? She has not come back. Oh. Okay.
I tried reaching out to her, the office, but it said she was unavailable when I tried to call.
Thank you, Mr. Nava. All right. There's a provision in the Texas Constitution about the courts of the state of Texas and that they are to be open to the public. However, the Texas legislature in its wisdom has provided an exception to that. It's found in section 5408 of the Texas Family Code, and that provides that when a child or children are under the age of 14, there is a presumption that the child's right to privacy outweighs the public's interest in participating or observing any hearings involving a child or children under the age of 14. Any remaining detention hearing or hearings that we have this morning will concern children under the age of 14. There's been no evidence brought forth to the court that shows that the public's right to participate in those hearings outweighs the presumption that children under the age of 14 have to privacy. Accordingly, the court will close any remaining hearings to the general public pursuant to Section 5008 of the Texas Family Code. I thank everyone who may have been watching these detention hearings. And I'll remind you that rebroadcasting, recording, all or part of any of these hearings is expressly forbidden. Violation of the court's order may